The next two speakers are Connie Cornell and Betsy Chestney. They're going to talk to you about the new city ordinance that we've got. Thank you.
Hi and welcome, and there still are seats up here, so if anybody needs a spot. Connie and I are talking together today on the new Austin ordinance, which it got a lot of attention in the press, and our phones started ringing, and employers like, what does this mean? So Connie, of course, probably everybody in the room's worked with Connie at some point. I feel like she's the, the queen of employment law in Austin. So Connie has been carefully digesting this new statute and coming up with every way in which the city's gotten it wrong in terms of making it very difficult on employers. But what we're going to do today is talk about sort of the law and background checks. I'm not going to get into the whole, FCRA stuff in a lot of detail, but I want to talk a little bit about the rules that we're already applying before this ordinance was passed, and then kind of set up the context for why Ban the Box came about, and then Connie's going to get into a little bit more of the nitty-gritty on what's actually required. So even before Austin passed this ordinance, there were already laws that were affecting the ways that employers could do background checks. Of course, the federal law is the Fair Credit Reporting Act, and so that has these very sort of strict compliance procedures. You guys are probably pretty aware that the forms have to be separate, nothing else can be on it, and it's a very just strict liability kind of, you have to follow this process. Then there are these other states and cities have come in and also started to impose some regulations and rules, including kind of mini FCRA type rules, and then also these Ban the Box laws. And so I think it's helpful to think about what the purpose of these two different types of laws are. The point of the FCRA is really about correcting mistakes. So if you're going to rely on somebody to run a background check, they run a background check and you're going to screen somebody out based on it, a lot of times they get it wrong. There might be, more than one Ted Smith in the world, and so one might have committed, embezzlement at in a previous lifetime, and another one didn't. And you don't want to screen out people for things they didn't do. So the point of the FCRA is just taking into account that these processes are not really perfect, and so we need to give people's opportunity to correct mistakes, and that's what it's for. Ban the Box has its origin in a different sort of philosophical concept, and I was joking with my colleagues that I'm going to quote Victor Hugo to you, but I'm not going to. But you guys all know Jean Valjean from Les Miserables if you're Broadway fans, if not Victor Hugo fans. And you know the whole story, right? That he got sent to jail for stealing a loaf of bread and that he couldn't feed his family, and that's why he went to jail to begin with. And then he gets out and he tries to follow the rules. He has his yellow ticket of leave and he shows it, and everywhere he goes, the employers say, go away. And so what happens to him? He is subjected to a life of squalor, underground job opportunities, and that's all that's available. So what does he do? He tears up his yellow ticket of leave. He doesn't let anybody know he's got this criminal history, and then, of course, he elevates to become the mayor of the city. Monsieur, what is it? Where's Ted in his French? But Monsieur the mayor, right? So the point of Ban the Box is the idea that, how we don't want to screen out people who have the opportunity to really be great employees because of something in their criminal history. And so Connie will talk about how the Austin ordinance sort of was based on those findings and how it's attempting to implement that. But getting back to the much less fun, and so the EEOC has published guidance, you guys are probably very aware of this, that talks about sort of along the Jean Valjean idea, but tied more to the categories that federal law prohibits discrimination based on, that if you screen out people based on arrest records or convictions, it's going to have a tendency to disproportionately screen out certain minority groups. So that's troubling. So what that means is if you're not following all of the correct procedures with regard to the FCRA and the Ban the Box rules and everything else, not only might you be subject to liability under the FCRA for not complying with their technical notice requirements, you could also invite some discrimination claims because people are going to say, you have this policy that screens out everybody for this type of a conviction that has a disproportionate impact on people of a certain origin, and it's not legitimately related to the qualifications that are necessary to do the job, and therefore that's discriminatory. So we kind of have a few different government agencies getting in on the act of trying to correct this problem. You've got the EEOC with its guidance. You've got the FTC, which is protects consumers, and so that the FCRA kind of is dealing with different types of background checks in different contexts. So we've got this alphabet soup of sort of agencies trying to address this fairly complicated problem. But I will say this is one area where I have a link in here. The stuff online is really good. Like there's very kind of straightforward, employer-friendly guidance on how to comply with these rules, and I really encourage you to look at them. But just, you know, a little bit of the background on the FCRA, which you should know, is that if you're governed by the FCRA, you must basically provide these pre-adverse action letters if there's any possibility of negative information from the background check could adversely affect the impact of the applicant and or the employee. So what's going on is you've got to give them a notice that you're going to do a background check, right? And then if something comes back in the background check, then afterwards, if there's a chance that you're going to rely on what's in that background check, you've got to tell them, we did a background check. We might rely on something that's in there. Here's a copy of it. And you have to provide, and the easiest thing to do is just to go here and print it out. You have to provide a copy of the summary of their rights.
So
yes?
For clarity, you only have to supply the copy if you're going to use it.
Right. So you have a separate notice that goes out at the beginning, right? It's a different form. But if you actually run the background check and something comes back, yes, that's when you have the obligation to provide that.
If nothing comes back, you don't have to provide the report.
Correct. If you're not going to use anything in there to make a decision. Make an adverse decision. So after you've given them the copy of their notices and you've given them the copy of the report, how long do you have to wait? This is one of those areas of the law where there's not really a specific rule. It just says you have to give a reasonable amount of time, and that's generally going to be pretty context specific. You know, if it comes back and it's like this person was convicted for, you know, was in jail for 20 years for committing all sorts of fraud and embezzlement, and this is somebody you're looking to hire to be a, you know, your CFO, right? So you give them the report and they're like, yeah, I totally did that. I mean, they're admitting it, they're not disputing it, you know it's relevant to the position you'd be hiring them for. You don't have to give them, you don't have to let it sit out there for several days or something. But generally, there's some sort of guidance in one of these various government publications that suggests 5 days might be a reasonable amount of time to wait in the ordinary situation where you've given them the letter, you've given them the report, you've given them the notice of their rights, so that they have some time to contact you, maybe find some documentation or something they need to show that there's something wrong with the report. And the other point is you're supposed to also be conducting this individualized assessment. And what is an individualized assessment? So as we talked about, you're not supposed to just rely on the fact that somebody was arrested or convicted. And those are actually two different things. Arrests, you have to be really careful. The EEOC does not like you relying on arrests at all. And why is that? Because an arrest is just an accusation. Right? So arrests and convictions not the same. Convictions, presumably, they've pled guilty or they've been convicted by a jury. So that's a lot more reliable that whatever is alleged to have happened probably happened. An arrest, we could all be arrested. It could be a mistake. And of course, everybody knows from all of the news coverage in recent months and years that certain populations get arrested at much higher rates than others. So you're compounding that whole adverse impact problem. But when you're talking about even convictions, you're supposed to look at what is the job and then what was the conviction about. So if it's a driving job, for instance, you probably want to look at things like DWIs that are recent. That might be pretty relevant if it's a driving job. If it's somebody filing books in a library, then probably DWI's not that relevant, right? So same for if somebody's handling money and you've got a conviction that's related to being dishonest or something along those lines, that would be a concern. People who are coming into contact with customers and things, if you've got violent kind of convictions for violent crimes, that's going to be something you're allowed to consider. And so the types of things you're supposed to consider are how recent was it? How severe? Are we talking about a little possession crime for marijuana when somebody was in college? Or are we talking about something that happened last week and that was a very serious sort of offense? And is it job related and consistent with business necessity? So that's the standard. So when you do that adverse action letter, there are specific rules that you put in there. So when you say, like, this last letter that you send them after you've made your adverse decision, you have to put the name, address, telephone number. So applicant or employee may obtain a free copy of the report from the CRA within 60 days. The CRA did not make the decision to take the adverse action and is unable to provide. So these are like we can provide these particular slides to you so that you don't have to keep up with them. But there's these detailed language, and it's all very, very technical and compliant. And Steve has a case going on right now that's an FCRA case, and he can tell you that it's amazingly technical. And the problem with it is it provides a private right of action. So if you're getting this stuff wrong, you can get sued in federal court, and it's these little tiny statutory penalties. I mean, it's not very much per violation, but the attorney's fees rack up really, really fast. So it's sort of like the FLSA claims, where even if you have just really small violations of the law, you can pay these big penalties for noncompliance. So that takes us out of the FCRA background and into.
Can I ask one question on that?
Yes.
Wait. So, the business necessity, et cetera, and I know you said it was.
So your question is, I'm going to repeat the question, because Scott told me I have to. So she is, part of what she does is place people, you hire individuals, right, and you place them with others who have requirements for what their backgrounds could be? No?
Our company does work for hire,
Oh, okay.
and there are very strict business necessity.
So the argument would be that that's a business necessity, but it's if you're talking about trying to protect yourself from a discrimination type claim, like let's say they injected a standard that was, we don't want anybody who's ever been convicted of anything, working here. Then that's pretty risky on just the discrimination law front, because it's going to be subject to that disparate impact type analysis, and Title VII is one of the places where you can have joint employer liability. So the claim could potentially be brought against both those entities. So you can't just rely on the fact, customer preference and customer requirements has long been something that people have tried to argue, we're not discriminating, it's our customers. They don't want to be waited on, they don't want men to serve them coffee on Southwest Airlines, or they don't want, black people to wait on them in the hotels in the South, right? So that can't be enough to get you past it. Now, if it's tied to some sort of specific industry requirement or something like that, that might be something different. Like if you have to be bonded, or those sorts of rules, those can be different situations.
I think you can pick up the phone. Is this something I missed the question because I was doing the mic.
So how do you coach people on how you communicate about?
Managers want to have
Okay.
that conversation and start talking.
Right. Well, to me, there's 4 critical pieces of paper under the Fair Credit Reporting Act, which is applied whenever you're using some outside service to gather this information. So the first is that you're disclosing that you're doing it. The second is you're getting authorization to do it, right? So they know you've done it. So to me, I don't think that hurts to pick up the phone and say, hey, we got it back. Let me read you what it says. And then you read it to them and say, this is something we may be taking into consideration. I'll be sending you the notice of that. But, I'll email it to you. When you get it, call me and let's have a chat. And then email it. That's what most of my clients do, is they email it and then they call. And if there's a logical explanation, then you get that logical explanation usually on the phone. And it comes up a lot where, somebody might have a hot check, and this, the explanation is that it was an ugly divorce, the spouse wiped out the account, the check started bouncing, but it was years ago, and they've gotten their credit back on track, that sort of thing. So, but it's criminal, so it shows up, and so then, but I don't see anything wrong with that. Anybody else?
When the chat is, that's what you guys are saying that.
Like, give me an example.
I think that's always a risk when managers start talking.
I would say that one thing we've learned, particularly in Steve's case that he's handling, is that they are very nitpicky about that disclosure and the authorization. So if you haven't had yours reviewed recently, I would take another look at those. If you're just relying on what your third party is giving you, that's written to protect them, not necessarily to protect you. So, and they don't all have it right either. So given that this is now the new hot spot for litigation, I would encourage you to have those things looked at, and then make sure you've got your pre-notice and your post-notice all ready to go and that they're clean. But yeah, hiring managers always want to, I just want to talk to him. I'm sure because he's great. I'm sure he's perfect for the job. Let me just clear this up. Okay, he did the murder, but he's really good at I had a witness once who said, yeah, I shot my wife 32 times. I'd do it again. I'm thinking, great. So glad this is not a face-to-face. But okay, so let's talk about yes.
Sorry, last question.
I do. I don't know that you have to. Does anybody know off the top of your head if you have to? You do.
If you've already sent it to them, then you don't, but if you haven't yet.
I think you have to for the post. For the pre, do you have to?
Yeah, no, the pre you do, because
Okay.
need to see it so that they can challenge it. So usually you're not going to.
Yeah. I don't see. It's their criminal history. I don't see the point of hiding the ball. It's like, this is what we got. So, we just have to make sure that we're asking for what we need and not more than what we need. How do you? Okay, got it. Okay, so we're going to talk about Austin. What did Austin do? And I love the expression "fair chance hiring ordinance" in an at-will state. Something about that just. Okay, Texas is at will, but we have fair chance hiring. Okay, but that's what we've got. So let's talk about what that means for the Austin employers. And all right, I thought I knew what I was doing. I don't know. I've got things coming out my ears here.
It's over by the speaker.
Thank you. Thank you. All right, so basically, this is the Jean Valjean issue, which is denying an employment opportunity to an otherwise qualified person based on the person's criminal history that is not relevant to the job under consideration is unjust. And it's based on that finding that the city council decided to act. Now, of course, when you see the ordinance and you read the ordinance, there's parts of it that you're just going, it doesn't make sense. They don't define this isn't going to work practically. I talked with the city attorney in charge of employment, and he goes like, you have to be at these meetings. I draft something, that's not necessarily what comes out. I'm like, okay, I got it, I get it. So anyway, so there's going to be some holes that they're going to have to plug in because you're going to see where those come up. And then they have the ability to do that through rulemaking. So it's going to be interesting to see how they make a rule for some of these because it's going to be, we said this, but that's not what we really meant. What we meant was X, though we said negative X. But it applies to who's an employer, okay? Who's an employer under the city act, the city ordinance? A person or entity that employs at least 15 individuals whose primary work location is in the city for each working day in each of 20 or more calendar weeks in the current or preceding calendar year. You'll notice that definition is very similar to the definition that is used under Title VII and ADA and the Texas Commission on Human Rights Act. But the 15 people have to be primarily employed here. So if you have 14 people employed primarily here, and you have a sales rep who's in Oklahoma or in Dallas or in Houston, then I would argue you don't meet that, right? You don't get there. So it has to be 15 primarily reporting to Austin. The city does not include the ETJs. What about employers based outside of Austin with 15 plus employees in Austin, hiring for cities other than Austin? That's Betsy's question.
I just say that because I think the way it's written, the way employer is defined, it's tricky to figure out exactly how far it reaches.
And it doesn't technically address the ETJ issue, but I did ask city attorney's office, and they say the intent is not for it to cover the ETJs. Yes?
So we are the ETJ, literally across the street from the city of Austin.
Uh-huh.
Everything we do is in the city of Austin.
This is not in writing anywhere, but last night at 5 o'clock, I emailed the employment lawyer and I said, does it apply to employers in the ETJ? And his definitive response was no. So, I have the email. So if you're one of our clients, I will give you the email, and he will regret doing me a favor. But do what?
What's an ATJ?
So, all right. Moving on. The city ordinance does not apply to governmental entities. It doesn't apply to bona fide Section 501c private membership clubs other than a labor organization, or a job for which a federal, state, or local law or compliance with legally mandated insurance or bond requirement would disqualify the individual based on criminal history. So they're trying to basically say if it would otherwise be legally mandated, we're not trying to mess with that. So it's the bottom line. So I think if you've got a law that you can point to that says we have to do this now because of this, but it needs to be inconsistent, in my view, with what the ordinance says. Okay, so what is a criminal history? It means an arrest, conviction, a nolo contender plea. Deferred adjudication is specifically referenced, so even if they cut a deal where, you know, it'll be dismissed if you keep your nose clean for X number of, and then we'll just let it go, that's going to be covered too. A felony criminal accusation, a Class B or Class A misdemeanor criminal accusation under state law, federal law, or comparable law of another state of the United States. So the whole gamut, pretty much. Prohibitions. Okay, here we get to what you can't do as an Austin employer under this ordinance. You can't publish information that even implies that criminal history will be an automatic disqualifier. So if you have in there, we do not hire anyone with a history of violent crimes. You know, that's going to be a violation of the ordinance. So you want to be very, very careful that nothing that you have in writing or that you're saying verbally is a statement or a publication that you have any kind of across the board. It doesn't matter what you say. It doesn't matter when you say it. It doesn't matter what mitigating factors exist. Bottom line, if you have done this, if you have this conviction or this type of arrest or this type of deal, we won't even consider you. That will be a violation. And probably a violation from the EEOC's perspective as well. You can't solicit or inquire about criminal history of an individual on an application. That's the ban the box part of it. So, you know, the applications that say, do you have a criminal history, and it has in small print, just because you say yes doesn't necessarily mean that you won't be considered or doesn't automatically exclude you from consideration. Not going to cut it anymore, okay? And for an Austin person, your application can't say that. I mean, it's just take the line out. It needs to come off of the application. And that's the whole concept of the ban the box, is that that shouldn't be a factor at that stage. They're just at the beginning levels. So let's see how far up they get before we start looking at that factor. That's the EEOC concept too. All right, an employer may not solicit or consider criminal history until after making a conditional employment offer to the individual. Now, this is the biggie. The EEOC does not go this far. I don't know of anything that would govern our folks in Texas, at least, that goes this far. Because what it basically says is you have to narrow it down to the one. You have to make an offer of employment to the one. And then you can ask for the criminal history and run the criminal background check, which creates ricocheted problems for employers no matter what the size. Yes?
Is it okay?
Yes.
Okay,
Yes.
okay.
Yes, that's okay. It can be a contingent offer. You just can't say, okay, we've narrowed it down to 3 people. We want all 3 people to go through a criminal background check, because if turns out our number 1 pick is going to be excluded on that reason, we still have a shot at number 2 or number 3. But what we don't want to do is we narrow it down to the 1. The 1 gets dinged out, but by the time we get around to making that, go through the process, we've lost candidates 2 and 3 because they've accepted opportunities elsewhere. So, yeah, so much fun. Okay, so that's the issue. Refuse to consider employing an individual who fails to provide criminal history before a conditional employment offer. So if they say, I'm not going to give it to you unless you give me an offer, you can't, fire them for that or refuse to consider them for that. So what is a conditional employment offer under the ordinance? It is an oral or written offer of employment by an employer or offer of placement in a staffing agency, staffing pool, that is conditioned solely, keyword solely, on the employer's evaluation of the individual's criminal history and any ADA authorized pre-employment medical exam. So you can still do the ADA stuff. But other than that, the only thing that can be conditioned on is this. The ordinance does not limit the withdrawal of a conditional offer of employment for any lawful reason. Now, Betsy and I were having this discussion because my frustration is, okay, most contingent offers will say this is contingent on your signing our confidentiality agreement, our standard proprietary information agreement, our non-solicitation agreement, our non-compete agreement. But that would make the offer contingent on something other than an ADA approved test or a background screen. So, which under, I mean, that, but then at the bottom, Betsy says, well, yeah, but at the bottom it says right here, it's not preventing you from withdrawing a conditional offer of employment for any lawful reason. So I'm like, okay, so I can withdraw it, but I can't tell them. So this is one of those things I think they're gonna have to iron out. In the meantime, best solution I can come up with is just when you're doing your offer letters, just state in there, you know, these are the terms of your offer, A, B, C, and then list, you know, a standardized, you know, confidentiality agreement, a standard, you know. I don't know what else to do, because then I could say, no, that's part of the offer. I didn't say it was conditioned upon it, you know, that's part of the offer. So if they accept the offer, they're accepting that as a term of the offer. I mean, we're talking legal nonsense, but, you know, it provide at least an argument around this whole concept that, no, you've added more conditions than what the ordinance allows you to add. And if somebody has a more creative way around that until we get some clarification, I'd love to know it. This is the one I'm really anxious to see how they fix this by rulemaking. I know we said solely, but we didn't really mean solely. So we'll see. An employer may not take adverse action based on criminal history unless the employer has determined that the individual is unsuitable for the job based on an individualized assessment conducted by the employer. So that's very similar to the EEOC. You're supposed to do an individualized assessment. All right, so that's not really anything terribly new. Like the Fair Credit Reporting Act, the employer must tell them in writing that the adverse action was based in part on the individual's criminal history. So if you're already complying with the two-phase letter, the pre-adverse action letter and the post-adverse action letter, you're already doing that. So that's not terribly new. Okay, what is an individualized assessment? Under the ordinance, it means an evaluation of the criminal history of an individual that includes, at the minimum, the following: the nature and gravity of any offense, the length of time since the offense and completion of the sentence, the nature and duties of the job for which the individual has applied. And the EEOC guidelines recommend consideration. They have a longer list of factors. So it's not saying you can't ask all those other factors. You know, I would go through and ask all the ones that the EEOC recommends, frankly. Just go through the list. And, you know, then you can chalk it up. I did my individualized assessment. I asked them all the questions. And this is the information that I got. And we're still not hiring, you know, the guy with 8 DWIs to drive the school bus, which is not. So, in any event. Retaliation has a standard. You can't retaliate for somebody who reports a violation or participates in any administrative proceeding under the chapter. So, now, the city ordinance expressly states that it does not preclude an employer from explaining to applicants in writing the individualized assessment system that the employer uses to consider criminal history. So, the concern by the city, the ban the box movement, is that you make up your mind. You're basically putting people in a position of electing out before they ever apply because they're assuming they won't get hired if you're running criminal background checks, right? But if you explain in writing what your policy is, and it's compliant with the city ordinance, and I would argue compliant with the EEOC recommended approach, then to me, that's not what you're doing. You're saying this is how we do it. Because what you don't want to do is get somebody through the whole process, and then you say, we're going to need your criminal history, and they're like, what? Nobody ever said that. Well, it's like, well, because the city told us we couldn't. Well, they didn't really say you couldn't. They said you could tell them in writing what your written policy, you know, what your policy is for the individualized assessment. So what I would suggest is having a policy that is compliant with EEOC's recommendations, compliant with the city ordinance, which is basically almost overlaps with, you know, much of the EEOC's points. It's not as broad. And then publish that, you know, then we look at the job, and we look at this, and we look at that, and we look at this and this and that, and then we make a determination. So if you...
So would that be something you would include with the employment application?
I wouldn't put it in the application, but I think you can publish it. I would put it probably separate. Yeah.
But give it to them.
Yeah, I would. Or you can put it online, or you could make, please look at our, key policies related to recruiting, and then go through and, have what is our recruiting process, who are we looking for, our band, whatever. Our individualized assessment of criminal histories, do you require drug testing, so those things that may be factors to be considered so that they know. Now, you may still have a certain number of people who elect not to apply, who would have been qualified if they'd at least given the individualized assessment a chance, but some won't even try. But I feel like it's unfair to have somebody go through the entire process and then you say, you got it, but now we want to do a criminal history, and they're like, uh-oh. So now you've wasted an awful lot of time for you and for them. So I would have what you want to do in writing, have it as a policy, give it to applicants or make it available to applicants, as a list of, whatever the things that you might provide as part of the application process. And then I think you avoid that kind of shock at the end. Yes?
If they have a license,
Yeah, because that's not criminal history.
just criminal, okay, not getting into driving.
Is just driving record, well, do you have a license to drive? I mean, you can ask if you have a license to drive.
But you can't ask the criminal history, so if they've been
Yeah.
charged with driving offenses or tickets, it's covered.
Yeah, you're right.
Can you ask, do you have an active driving record?
Yeah, I think the distinction is probably not getting into the reasons. Like, do you have a license?
Do you have a license?
The valid license. They will have
A valid license. See, collectively, we got an answer. Okay. Yes, we're out of time, so.
Wait, just do the last couple of, because they're.
Okay. Okay, so basically, the Austin Fair Employment Fair Housing Group is going to be enforcing this. There's a 90-day statute of limitations, but from the time that they figure out that the violation occurred, but no more than a year. And then
And the big
they
thing
can,
is there is no private right of action.
yes, they can't sue you for it.
over this.
So the only thing that can happen is the city can assess a civil penalty. Civil penalties are $500 a violation, but they give you an opportunity to cure. In essence, you get 10 days to fix it if you get the letter of violation. So they're really looking for compliance more than they are looking for money, unlike some agencies. And they are, and there's other exceptions that help to, you can make arguments.
You have until April 2017.
Yeah.
To get your stuff in order.
So you have until next spring. And that's it.